Ready, start. Appellant has also submitted before this court photographs and coordinates of the graves of his aunt and grandfather, in the area specified for Christians in the village graveyard, full stop. Furthermore, it was submitted that the existence of oral permission by the Gram Panchayat is confirmed by the practice of burying Christians from the last few decades, including appellant's grandfather and aunt being buried in the area specified for Christians, full stop. Therefore, according to the appellant, there indubitably is an established practice, full stop. In that light, it was contended that all these decades the local Gram Panchayat, on the basis of oral permission, had permitted Christian burials in the village itself, and the photographs of the graves of appellant's family members stand as a testimony to the said fact, full stop. However, the High Court erred in insisting upon written permission or relying upon the certificate issued by the Sarpanch submitted to the court, full stop. It was further submitted that this court may direct the respondents not to create any hindrance to the burial of appellant's father adjacent to the burials of his grandfather and aunt, full stop. In page 17 of 37 alternative, it was submitted that permission may be granted to the appellant herein to bury his father in his private agricultural land, which would in a way give a quietus to the controversy, full stop. Per contra, learned Solicitor General Sri Tushar Mehta led the arguments for the respondents along with the learned Advocate General for the state and other counsel for the respondent authorities by contending that constitutional issues under Article 25 would arise in this case, which could be argued at length by both sides, full stop. However, having regard to the facts of the present case and particularly the fact that the body of the appellant's father is being preserved at the mortuary of the district hospital and medical college at Jagdalpur since 7/1/2025, as a resolution to the controversy between the parties, the appellant could bury his father at the burial ground at Karkapal, which is about 20-25 kilometers from Chhindwara village, and the appellant would be given all support by the state government in that regard, full stop. In this regard, reliance was placed on the subsequent two affidavits filed on behalf of the respondents, full stop. Learned Solicitor General contended that the appellant is prosecuting a cause which could be given a quietus by the appellant being permitted to bury his father at Karkapal graveyard, and the matter could be thus concluded, full stop. By way of reply, learned senior counsel submitted that if the appellant desired to conduct the funeral rites of his deceased father at Karkapal graveyard, which is now being suggested by the respondents, there was no necessity for him to have made a grievance on the touchstone of hostile discrimination by filing the writ petition before the High Court, full stop. On the other hand, it is the case of the appellant that owing to unnecessary objection and threats being raised and orchestrated for conducting the funeral rites of his father in the village graveyard, he had made representations, full stop.